Mr. Aaron Quiet.
Get you back here, Charlotte.
Aaron Quiet, 26 CR 840. Can you hear me?
Yeah, I have a request.
I can't really hear Mr. Quiet. Mr. Quiet, can you hear me?
Yeah, I have a request.
I can't really hear him.
Hey, Mr. Quiet, you gotta speak right into the door. Not right now.
Mr. Quiet, can you try to speak a little bit more through that door so to get into that speaker the deputy's holding?
I have a request.
He keeps stating that he has a request, Your Honor.
Well, if you have a request, I'd be happy to hear it, but if you say it where you're at, I can't hear you.
I have a request.
Oh, I can hear you now. Okay. Let me tell you something really quickly, and then we'll talk about your request, okay? So in this case, it's 26 CR 840. Mr. Quiet appears in custody at the jail. It is a first appearance. Bond has been set at $3,500 cash or surety. You were advised of the complaint when you were down in courtroom 1A. You have one class 6 felony assault in the 3rd degree against an at-risk person. Mr. Quiet, would you like the court to appoint the public defender today?
No, I have a request.
All right. So you do not want a public defender, is that correct?
Correct.
All right. What's your request?
Now on, can you refer to me as Aaron and not my full name that you have to?
Can I refer to you as Aaron?
Yeah,
Why?
privacy.
I can't hear you.
Privacy.
Privacy? Okay. What's your next request?
I have a petition.
All right, go ahead.
I'd like to petition the court for a reduction or dismissal of my bail. I believe the bail that was set in this case for the offense that allegedly occurred on June 10th was excessive and in violation of the 8th Amendment of the United States Constitution and Section 20, Article 2 of the Constitution of the State of Colorado. As held in People v. Jones, if bail is set at an excessive amount, the defendant has the right to petition for reduction of bail or appeal the bail decision. In determining whether or not bail was set an excessive amount, the court should look to the purpose of setting bail. Lucero v. District Court and LOW.
Hey, Mr. Quiet, let me just cut you off right now. This is a victim's rights amendment case. The court cannot legally address your bond today. We can set it for a bond review, but I can't review it today.
Lucero v. District Court and LOW v. District Court held that the purpose of bail is to ensure the defendant's presence at the time.
Right, I'm aware of the case law, but I can't address your bond today, Mr. Quiet. You're wasting your time. So I can set it for a bond review if you'd like.
Yeah.
All right, what's your next request?
In accordance with Colorado Rules of Criminal Procedure Rule 5, I would like to request a preliminary hearing. Further, to satisfy Colorado Revised Statute 18.6.105, I believe the court should set the date for the as soon as possible. That section states that, quote, consistent with the constitutional right to a speedy trial, all cases involving the commission of a crime against an average person must take precedence before the court, and the court shall hear these cases as soon as possible after.
Yeah, you have a right to a preliminary hearing. If you're requesting one, I'll get it set. Is that what you're requesting?
Yeah, and further, to satisfy Colorado Revised Statute 18.6.5.105, I believe the court should set the date for the preliminary hearing as soon as possible.
All right, let me ask you some questions, okay? We need to talk about your waiver of an attorney. All right, you understand you have a right to have an attorney?
Yeah,
You understand you have a right to represent yourself?
yeah,
All right, the court has to engage in a process where I have to use extreme caution in obtaining a waiver of counsel. I have to indulge every reasonable presumption against finding a waiver of counsel. And again, I have to, I have to assess your background and experience, conduct, and history of any mental illness in determining whether there's a waiver that is voluntary, knowing, and intelligent. So do you understand that you have the right to be represented by counsel throughout these proceedings?
Before I answer that, I have another request.
No, you're going to answer this question right now. Do you understand that you have the right to be represented by counsel throughout these proceedings?
Before I answer that, I have another request.
I can't find a waiver. I'm going to appoint the public defender. The public defender will be appointed in this case. Mr. Quiet does qualify given he is in custody. He has requested a preliminary hearing within 35 days.
I will represent myself.
You won't answer my question, so I can't make the requisite findings.
I'll answer your questions.
It's not a game, Mr. Quiet. I gave you your opportunity.
The police deliberately prevented me from appearing in court today to stop me from delivering this statement.
All right, I've muted Mr. Quiet. I'm going to set a preliminary hearing. It must be set before July 30th. Are the people available for a preliminary hearing on July 15th at 4:30? Actually, you know what? Let's set it at 4.
July.
Is the court appointing me or not?
Yes.
July 15th at 4?
Yes.
People are available.
All right.
I could do that.
I can't find under Arguello a knowing involuntary waiver because he won't answer the questions I'm asking him. So the court will appoint the public defender. We'll set the preliminary hearing July 15th at 4. That is when I will see Mr. Quiet. That is the soonest possible date the court has for that preliminary hearing. Get that, or you just want to go over? They'll email us and figure it out if it's a problem, so you can head out. All right. We ready on Jason Thompson? This is 25 CR 5116, Jason Thompson, who appears on bond with Ms. Taylor. Case comes on for sentencing. Parties ready to proceed to sentencing?
Yes, Judge.
Your Honor, I had emailed Mr. Thompson a copy of the PSI, which is 32 pages long, on July 16th. It sounds like he hasn't reviewed it and would like a chance to review it, so
Wait, why hasn't he reviewed it if you emailed it to him on July 16th?
I don't think that he
My-
checked his email.
Yeah, my phone broke. I got a Razor. I was up high on a I-beam for the company and I sat on a bolt and it broke. I didn't realize that the PSI had came in and I didn't realize it was that long. Now I'm hearing about it.
What date did you email it to him?
July
16th.
16th.
18.
It's June 20th.
No, sorry, June 16th at 1 p.m.
Okay, June 16th.
I've been out of town on a job, so I haven't had a chance to. I'm in town now. I can get a new phone. But I honestly, they expect me to stay out there on the job. It's a little tiny town of 5,000.
All right, anything from the people?
I guess I would ask first if the court has had an opportunity to review the video.
I have.
I would ask to just move forward then at this point. He's had the opportunity to review the PSI and hasn't.
The video.
I do think it's pretty reasonable that you would have gotten it 9 days ago. I don't understand why.
I have a hotel phone at that job so that I can communicate with the boss. I just, didn't have that. I just got a computer yesterday.
28
Happy to set it
pages.
up.
Do you have a copy of it? You can go sit in the hallway and read it. I'll be happy to recall them.
Are you able to read it?
I didn't bring my glasses, but they broke in half, actually.
Your phone broke, glasses
Yeah.
broke, didn't check your email.
I just don't think that I would have time to like read it out loud to him. That would take a long
Well, I
time.
don't think that would be reasonable.
But I think that he also has an opportunity to review it and respond if he has any factual corrections or things
Well,
like
he
that.
does, but he's had that opportunity. I mean, I can't make him read it. He has to have an opportunity to receive it, read it, and give input, make corrections or additions if he wishes, but he's had it for 9 days.
Well, I haven't
Make him
had
read it. He doesn't have to read it.
I would like to read it.
Well,
I
sure,
haven't
but
had
you
it.
had it 9 days ago.
You're saying my email does? It's probably in there, no doubt.
I mean, if you're facing a criminal case and you're coming up for sentencing, I would think you would want to check your email. Seems more than reasonable to me. You're going to come back on June 30th at 11.
Thank you, Judge.
So what are you doing with Mr. Thompson's case?
Yes, Your Honor, he's still here, and given the distance that he's going to have to travel to come back on June 30th, he would, if the court is willing, like to have the case recalled and just be sentenced today.
Are the people all right with that?
Yeah, Your Honor. Yes.
All right, this is 25 CR 5116. Jason Thompson. Mr. Thompson, are you not going to read the PSI?
I am not.
All right. Are you all right with moving forward, having not read the PSI?
I am.
Okay. Sorry. Sorry. Give me just 1 minute. Are there any additions or corrections that need to be made to the PSI?
I'm not aware of any.
Not from the people.
All right. There's nobody else in the courtroom that isn't part of staff of some agency, so nobody else is probably here to make a statement. Any argument from the people?
Yes, Your Honor. Ultimately, the people would be asking the court to sentence the defendant to 4 years of supervised probation with all the terms and conditions that are recommended on pages 25 and 26 of the PSI. However, we would be asking to increase the community service that's recommended from 48 hours to 100 hours, given the aggravation here in the driving behavior exhibited by the defendant. I had already submitted the dash camera footage of the eluding incident for the court to review. And I do believe that 4 years is appropriate, given that he has probably one of the longest criminal driving histories that I've seen on a PSI, and I think that that's
It's extensive.
yeah, and it's definitely extensive. So I would ask the court to also impose a condition as part of the probation to not receive any further traffic citations at all. I know the typical term is nothing more than 4 points. I would ask for no driving, basically, without a valid license. So I do think that's appropriate here, given his history. I think that there was some confusion on the part of the defendant about the star chase system. I had clarified some of this with Ms. Taylor, but the star chase had been deployed. The court can see that on the dash camera footage, but basically what we learned by looking at that was that the actual GPS locating system doesn't come online until the officer goes in and actually activates it. And so as soon as the officer pulls off to the side of the road, discontinues pursuit, that's when we start getting GPS readings from the vehicle. And that's how the officers were ultimately able to locate the defendant at the stoplight, which is mentioned by the defendant. He's also stopped at a stoplight.
Oh, I'm so sorry. I'm reading it too.
And so the initial pursuit lasted around 5 minutes before the officer discontinued as the defendant was driving into oncoming traffic in the eastbound lane toward another approaching vehicle. This is visible on the officer's dash cam, which is why I wanted to provide that to the court. And so with all of that in mind, that would be our recommendation. I do believe that that's appropriate given the defendant's history.
And how long of a probationary sentence are you asking for?
We would ask for 4 years, Your Honor.
All right. Ms. Taylor?
Thank you. I'd be asking for 1 year probation with the treatment terms listed in the PSI. I think 1 year would be enough to do the types of treatment that are recommended. In looking at his driver's history, there are some priors, but I have also seen a lot of clients fall into this cycle where it is difficult to get a suspended license reinstated, and it's also pretty much near impossible to to live in this state without having some sort of personal transportation because we don't have a very good public transportation system. I know Mr. Thompson has disagreed with some of the ways that police are characterizing the evidence just based on the fact that his vehicle is a bit of an older model. It's not in the best shape. He doesn't have, I think, the side mirrors, or some of his mirrors are missing, and then the back window is very tinted to the point where he just doesn't always have good visibility. So he does dispute that he was knowingly eluding that entire time. I do think that if we went to trial, that the prosecution may have some convincing evidence to present to the juries, which is why we're going forward with a plea, but that would be my request.
All right. Mr. Thompson, anything you'd like me to know today?
So,
Oh, sorry, Your Honor, one more thing. He has already served at least 90 days of jail, so if the court is inclined to impose any jail time, I would just ask that the court give him that credit for time served.
And we're in agreement on the credit for time served, Judge.
All right. All right. Anything you want me to know?
Judge, so I think what is important to know is I pulled over on the side of the road. I never went across oncoming traffic.
You did.
There was no car moving. I parked with other cars so that I could get out of the way of.
Made a right turn and went into oncoming traffic.
I found a place to park because it looked safe. I figured they thought it was safe, and I parked with them because I didn't know if it was a high-speed chase behind me. And I was on a dirt road with no shoulders. So I slowed down when I seen the lights. I went to the asphalt and parked with the other cars. That's just what happened. Okay, that's just what I know. And then nobody came, gave me a ticket. I drove off, waited at a red light. It never turned green. That's where they arrested me. Okay, I just want to be able to say that so that you know, take that into consideration. I don't know how else to fight that, but the rest of it, I'm not contesting. You know, probation, community hours, etc. I would like to keep my job. I am gainfully employed, which has been a while, but I have managed to make sure that I got a job. I've got all clean UAs, haven't missed one. Scheduled to take one today. I put myself on that schedule like I do every time I'm in Fort Collins or anytime there's a discrepancy. I know the first run, you know, I was missing because I couldn't keep up with the color code or whatever. I know I missed some. But then when I came back on this time, I made sure every UA was clean. For the last year, all my UAs have been clean. So I haven't veered off the road to success. And I do believe if there's a year of treatment, a year of whatever the probation, I can go through that with flying colors, attend, participate. I don't have a problem with that. The only problem I have is, somebody saying something, and that's where the star chart came in. It didn't start until after I was parked, and then it just seemed mysterious to me that, we couldn't get the last dirt road before that. It just started at 30 miles an hour or something, and I would have rather have had that to show that I stopped. That was the only reason that it came to a 0. But you can take that in. It sounds like you get that I was on the side of the road when nobody came to a ticket. And other than that, I will do everything that I'm supposed to. Don't want to take any more of the court's time. I appreciate you letting me get back to the job so that I can keep a job. And I guess that's it.
All right. So
And I have 0 eluding charges on my record. So it's just like a pattern that I know I have a lot of cancellations and stuff, but I'm saying I've never eluded.
it's hard to give you credit for something that you're supposed to be doing anyway. Like saying I've never had an eluding charge,
Well, I'm
or
just-
like saying,
It kind of lends to the pattern that maybe I didn't elude. I was at a red light. I still waited for the ticket, but I'd rather go to work. I know
well,
you guys would rather me integrate and just be successful.
I'm looking at but I don't know if that's possible at this point. I've got a class 3 misdemeanor disorderly conduct in 1988, a long time ago, but it just keeps going. Petty theft misdemeanor in San Bernardino in 89. Menacing misdemeanor in 89 in Weld County, along with a criminal impersonation, class 6 felony and unlawful carrying a concealed weapon, class 2 misdemeanor, burglary, class 4 felony in 1990, possession with intent, class 4 felony, Weld County, 96, theft by receiving misdemeanor, 96, Weld County, class 5 felony, controlled substance possession in 2000 in Weld County,
I have broke the cycle, Judge. I've been
Let's go.
10 years,
class
10 years
5
at
felony,
least.
2001, class 6 felony, Jefferson County, 2005, class 1 misdemeanor, Jefferson County, 2005, no insurance, 2006, red light violation, 2006, driving without a license, 2007.
I do have a license. It's valid.
Driving without a license, 2008. Theft by receiving, class 4 felony, 2009. Driving under restraint, 2009. Marijuana possession, petty offense 2, 2009. Driving under restraint, 2010. Driving under restraint again, 2010.
So Judge, can I say something?
No. Controlled substance possession of meth, 2010, class 6 felony. 2011, driving after revocation prohibited. 2012, driving with a revoked license. Eluding a police officer. Traffic offense 2, 2012. 2015, driving after revocation prohibited. Registration of a fictitious plate. Driving under restraint, 2016. Driving after revocation prohibited, 2016. Driving after revocation prohibited, 2017. Driving with an unauthorized person, traffic infraction B, 2020. I'm not so concerned about that one.
So I have registered.
Done. Class 8 misdemeanor, 2021. Possession of controlled substance, Dallas County, Texas. Third degree assault, M2, 2022. And then you got a bunch of pending stuff. Look, man.
All of that is dropped. All the pending stuff is dismissed now.
Yo.
The last 4 years of driving is dismissed.
I don't need you to chime in. Mr. Thompson, here's the deal. I think your criminal history and your entire existence that I've seen as an adult can lend itself to one thing. And here's what it is. I'm going to read to you what you said about this offense. You said, I did not know I was in the middle of a high-speed chase on a dirt road. That defies logic. It defies the facts. It says, I never went into oncoming traffic. That also defies the facts. So you just lie to yourself. You keep lying to yourself. You've done that forever, and you're lying to yourself now. You maybe believe your own lies, but the problem is, I don't. I know that what you're saying is not true. I mean, it's clear. I've watched the video. There's no possible way what you're saying is true. You may believe it. That doesn't make it true. I am really struggling with the probationary sentence just based on this criminal history. I am really concerned about his ability to remain law-abiding. I mean, it's just excuse after excuse after excuse. I mean, even today when you came in for sentencing, it was just my glasses broke, my phone broke. I mean, you've got an excuse for everything. So, I mean, I'm
I
going to
came back
approve.
for-
I'm going to approve it, and I will sentence you in accordance with it. But you better not come back to this courtroom. The court's going to sentence you to 4 years of probation. The court will authorize transfer of supervision to Weld County. No alcohol or illicit drugs. Submit to random substance abuse testing as directed by probation. You will complete 100 hours of useful public service. Submit to a substance abuse eval and follow through with all recommended treatment. You'll complete the cognitive behavior therapy, the MRT, participate in any restorative justice initiatives as directed by supervising probation. You will make payments of restitution costs and fees. There's no restitution being requested. Is that correct?
No, Your Honor.
Not even for the Star Chase replacement?
I don't believe so. I can double check.
All right. The court will order that you remain law-abiding and that you receive no traffic citations above 2 points. 2 points or above, to say it more accurately. Anything else from the people?
Your Honor, sorry. It sounds like he is saying he lives in Denver rather than Weld County.
I will authorize transfer to Denver County.
Your Honor, it does look like there is a request, but we don't have it formalized. I think there's also an invoice for prisoner transport expenses. If we could have 63 days ordered just for us to get that together into a packet, I think we're still looking for a final total.
All right, the court will authorize that time frame. I mean, there is restitution that would be owed for at least the Star Chase and cost of transportation from Adams County. Court will give you 63 days to file for that, 21 days to object. The agreement is for the 3413, so that looks like it's in there, but the rest would be the restitution.
And that's the transport cost.
Correct.
For the
And
Star
that's
Chase.
agreed to. All right. You need to go to probation today by the close of business in Larimer County before you go back to Denver.
Okay,
All right.
appreciate it.
All right, good luck, Mr. Thompson.
26 CR 750. All right. 26 CR 750. Sir, can you state your name for me?
Devontae Gonzalez.
All right. Mr. Gonzalez, you're here. You just needed to go reapply for the public defender.
Yes, sir.
Did you do that?
Yeah, I did.
All right.
He qualifies.
All right. The court will reappoint the public defender because you qualified in custody. Yeah. Can I help you?
Yes, I'm the surety on this case. I'm requesting bond revocation at this time.
Okay. What's your name?
Andy Enright.
All right. Ms. Enright, as the surety, you do have the right to request that you be released from the obligation. Give me just one moment. The bond was 10,000 cash or surety. That will remain the bond. You are released from your obligation, and then Mr. Gonzalez, have a seat over here. You're going to be taken back into custody. In the meantime, I will have you come back on August 4th at 9 for possible disposition.
And Your Honor, which attorney was appointed, please?
Attorney Barton, when this your case?
Yes, Judge, this is obviously news to me. So I was just, it's not a situation I'm super familiar with. And I'm just trying to look at the statute about when a surety can be essentially removed from a bond.
Yeah, they can request to be removed from a bond at any time, and the individual can be taken back into custody, but the court cannot relieve them of their obligation unless the individual is in custody, but they can request to be released from the bond at any time. I just can't grant the request unless they're actually in custody, and he will be in custody, so the surety can be
What's the
released.
grounds for him being placed into custody?
It doesn't matter. The surety can request to be released. It's a surety bond, and if the surety requests to be released from their obligation, he gets taken back into custody.
What did I do? Or why?
There doesn't need to be a reason. The surety can just the surety can request to be released at any time.
So what's the court's question?
When you want to come back, August 4th?
Yeah, that's the soonest we have.
16-4-110, upon surrender of the defendant into custody prior to the judgment against the surety entering, the surety can be released from their obligation, and that's what just happened. So the bond is the same bond. He just would have to post it with a different surety or post it as cash. So I will have him back on August 4th at 9.
My question about that part of the statute, upon surrender of him into custody, to me, that suggests there's already some sort of warrant if you're surrendering somebody.
All right, well, he's being taken into custody because the surety can be request to be released from their obligation at any time.
Ask why?
There doesn't need to be, you can ask the surety that, but you're going to do that on your own time. You can give her a call.
Shannon McGrath on behalf of Ms. Lordell Casares, who appears in person in custody. This was set over for plea and sentencing hearing today. We have that plea paperwork that we read into the record last time, if the court wishes me to read that again.
Please.
It would be admitting to the violations in the petition to revoke probation. It was a deferred judgment sentence, which would mean with the revocation, the conviction would enter. A regrant of supervised probation open to the court with the addition of the Making Better Choices class. And we did go through the 5 and 32 advisements.
Actually, it's been uploaded, so I can use yesterday's. Ms. Lordell Casares, here's where we got crosswise last time. You weren't making any admissions to any wrongdoing, and you were in denial. So I want to make sure you understand your options. You always have a right to have a hearing before a judge where it is the DA's burden to prove the allegations. At the hearing, you have a right to confront and cross-examine witnesses, the right to testify, and the right to put witness and evidence in your own behalf. Now, the DA's burden of proof is by what we call preponderance of the evidence, which means is it more likely than not? Again, at the hearing, you have a right to confront and cross-examine witnesses, a right to testify, and a right to put on witnesses and evidence in your behalf. The possible penalty in this case carries up to 120 days of jail, plus the loss of the deferred sentence. You have a right to have a lawyer. You do have a court-appointed lawyer here today. Are you satisfied with her services? The allegations are that you missed UAs on April 16th, March 31st, March 5th, February 18th, February 2nd, January 17th, January 7th, December 23rd of last year, December 19th of last year. That you were referred to Catholic Charities for parenting classes and you did not verify enrollment in those classes. That you were referred to Health Solutions for mental health evaluation and you failed to provide verification of enrollment and treatment. That you also missed probation appointments on May 1st and March 3rd of this year. Do you understand those allegations?
Yes.
Now, this is where we got a problem. When I started asking you about those allegations, you pretty much denied every single one of them.
I didn't mean to do that. I agree with the allegations. I don't know what I was trying to explain certain things, but it's.
Well, let me ask this. On September 16th of last year, you were referred to Catholic Charities to do the parenting class. Did you do the parenting class?
I haven't finished all of them, no.
How many were you ordered to do?
I don't even know how many they're supposed to do. I signed up at a different place now.
So when you went in September, did you follow through with your September classes that they told you to do?
No, I haven't done any of
These are not trick questions.
No, I haven't finished the class, no.
You did the mental health evaluation, but did you do any of the follow-up classes? I'll accept the admission, find it knowing, intelligent, and voluntary. Any statement from the prosecution?
You have nothing further to add, Your Honor.
Judge, what I'll note for the court, for Mr. Delxaras is that my understanding is since, I think right before getting taken into custody, it sounds like her father died. I know that she is dealing with, the grief of that, but it's also kind of eye-opening to her. That is, and then also being in custody now. Her goal now is to go and actually not only do the intake for those treatment and classes, but actually follow through with those classes so that she can complete probation successfully, move forward and, be there for her family and for herself. Obviously, as the court is aware, with this plea, the conviction is entering, so she's going to have that on her record. It's not something she can now get dismissed. And she's having the additional class added on, which I know she's, I believe, going to have to pay for as well. So that isn't a sanction in and of itself, and she's been sitting in custody waiting for this to be done. I know that the regrant was what was recommended by probation, both in the complaint, and it sounds like in their talks with the district attorney prior to this plea going forward. So we would ask the court to put her back on probation and allow her to get started in re-enrolling in classes and doing what she needs to do on probation so that she can close this out.
Is there anything you'd like me to know?
Yeah. There's anything else you want to tell me? I don't think so, Your Honor.
Mr. O'Dell, I'm looking, and I want you to know this. My struggle with you is how many times the probation officer has given you warnings. And I'm looking through this evaluation, and I want you to hear this from me. I'm going to go in reverse order. This is going back to June of last year. Failure to contact PO, missed office appointments, scheduled visits, warning, reprimand, written and verbal. Couple positives in there. But October 9th, attend appointments on time. Again, failure to pay fees, restitution, again, warnings given. November 6th, failure to contact PO, including missed office appointments and scheduled visits. Probation gives you geographic restrictions as a warning, as well as verbal reprimands. November 13th, a week later, failure to submit to a test, warning, reprimand given. December 11th, violation of other conditions relating to alcohol or drugs, start to increase UA testing, secondary, warning, reprimand given. January 12th, failure to submit to testing, failure to complete evaluations, warning, reprimand given, twice. February 3rd, failure to submit to testing, failure to enroll in evaluation, failure to complete parenting classes, warning, reprimand given. March 3rd, failure to contact PO, missed office appointments, warning, reprimand given. April 23rd, failure to submit to tests, failure to comply with PO instructions, failure to enroll in evaluation as required. Increased reporting, secondary, warning, reprimands given. May 5th, failure to report for summons for revocation, failure to contact probation officer, including missed appointments and scheduled field visits. Warning, reprimand given. At what point do we stop giving you warnings? Do I just lock you up? Because I will tell you, my view is if probation has already given you all these warnings, I hate when they do this. They file a revocation and it's basically the equivalent of saying, wait till dad gets home when they ask the judge to now handle the case. My view is if they have already used all those tools in the toolbox, probation is considered a privilege, not a right, and warnings without consequence are irrelevant.
I understand that, sir.
But you also said that to your probation officer, and that's why I wanted you to see what they sent me. You had a chance to keep this off your record and did not take this case seriously.
I was going through a lot and I now have had a lot of time to, it's hard to, when you're trying to not do drugs, like when you're on the streets. I've come in here and now
These are consequences you have made. And if you don't want to change your lifestyle, then you sit in custody.
I do want, I do want to, and I'm serious. It's kind of,
The only way it works is when you show up and do what you're supposed to do. If you don't do it, then you might as well just serve out your time in county jail and deal with the consequences later.
I want a chance to do this, like how it needs to be done. I'm ready to do that.
How's the law? What's the longest you've ever been in jail?
Probably 40 days. But that was like a long time back, long time with like 2014 or something.
My point is, at what point does a judge say, I'm not giving you warnings anymore, I'm just locking you up? I don't believe in empty threats. You got to hear that from me. I don't believe in them. They're worthless.
I've been on probation for except for this. It's the first time that I've kind of messed up the whole thing with me, and I do apologize for that, and I'm ready to completely take it serious. And I think I've had to start from being in jail this time, being able to stop doing drugs at least, because when I'm out there, it's a totally different thing, and so that kind of helps a lot. And on top of that,
So you've been in custody 7 days now, right?
No,
15
it's,
Judge.
yeah.
Oh, wait, since when?
It's been since June 11th, so.
Oh, right, I was looking at the 18th. Thank you. I'm accepting it. If I was not going to accept it, I wouldn't be giving you this kind of lecture. But I don't do it twice. Because if these arguments are made in front of me before, there's that old adage, fool me once, shame on you, fool me twice, shame on me. I don't believe in giving 15 warnings like your probation officer did. I just don't believe in it. The only way probation works is if you're willing to work at it. And as far as I can tell, you had Ray Velez, who's a great probation officer. He works with people. He's one of our most senior officers we have. I'll accept the offer, the order. I'll order 18 months supervised probation with original terms and conditions, including any mental health evaluation and treatment as required. It's 14 days jail with 14 days credit. And I'll order you released today. You must report to probation by the end of business tomorrow.
Just for the record, I hear what the court's saying. I do think it's 15 days.
I'll take your word for it. 15 days credit.
Thank you,
I think I
Robert.
still had yesterday on my mind.
I got you. Does she need a sheet for the, or any referral for the class or?
No.
Judge, can I call Terry or ticket, please?
It's going to be 26M 724 and 26M 600.
Oh, I know you meant to show Smith.
Judge Gray Fitzgerald on behalf of Mr. Ortega, who appears in person in custody. We're on for a plea this morning. We do appreciate the court squeezing us in this morning. We do have a disposition for the court's consideration. In 26M 724, Mr. Ortega will be pleading guilty to violation of a civil protection order as a class 2 misdemeanor. The sentence would be open to the court and be capped at 9 days Pueblo County Jail, and it would dismiss the other case. May I
Okay.
approach?
You may.
I can write it down.
And I have fully advised Mr. Ortega under Rules 5 and 11 as well.
Mr. Ortega, I have to do this for you. I know these were older restraining orders, but I was trying to explain them to you,
Yeah.
that they stay in effect. Permanent means permanent. So if it went to trial, what the DA would have to prove is that, let me pull it up. That you, after being served with a restraining order, or acquiring from the courts or law enforcement personnel, actual knowledge of the contents of the restraining order. You knowingly contacted Andrea Iwasu, a protected person, a type of conduct that is not allowed by the protection order way back in 2005. They'd have to show you did it knowingly, and a person acts knowingly with respect to any conduct or circumstance described by the statute defining the offense. When you're aware that your conduct is of such nature or such circumstance exists. A person acts knowingly with respect to the result of the conduct when they're aware that the conduct is practically certain to cause the result. Do you understand that? Do you have any questions about that? Any plea has to be voluntary. That means it cannot be the result of undue influence, coercion, or outside pressure by anyone. Is this voluntary on your part? Do you read and write okay?
Yes.
And I'm asking that because judges aren't bound by any promises or representations that anyone makes about the sentence or the terms of the sentence, unless they're orally put on the record, like I'm doing right now.
Yeah.
Or in writing in the plea agreement itself. Does this make sense?
Yes.
How far did you get in school, sir?
I got my GD.
Okay, and are these your signatures both on the plea agreement and the 5 and 11?
Yes.
Counsel, this is an M2. I can take it. It's not a VRA case. I can take it as a paper plea.
Yes, Judge.
How do you plead, Mr. Ortega?
Guilty, Your Honor.
I'll accept the plea, find it knowing, intelligent, and voluntary. Mr. Brim, any statement about the prosecution?
We have nothing further to add, Your Honor.
What is the prosecution seeking,
Sorry.
since it's an open sentence? And I don't know if there's been any discussion with the victim.
So we have not had contact with the victim after attempting to reach out to them. We think a reasonable jail of around 10 to 45 days would be appropriate, Your Honor.
Mr. Fitzgerald?
On behalf of Mr. Ortega, I honestly, if the court is willing to close him out with 10 days jail, you know, if that's what we would sign him up for as well. But what I'll first note for the court is that, as the court has mentioned, this is a permanent restraining order from 2005. In reviewing the discovery with Mr. Ortega, what became obviously clear to me was that he was extremely honest with everyone the entire time. Functionally told the officers everything. Because there was genuine confusion about the protection order. Obviously, I understand it seems as if there was some potentially invited contact, and then it just kind of snowballed into functionally living together. But I have spoken with Mr. Ortega yesterday. He obviously understands the protection order. He understands all the provisions of the protection order now. And is willing and able to abide by all of those provisions of the protection order, standing before the court today. Mr. Ortega does have a great support system with his daughter. I know his daughter was mentioned in the newer case as well.
I saw that.
And she's a great support system for him. She can certainly assist him in, abiding by the protection order. Again, I just would finally note for the court that in speaking with Mr. Ortega, I do believe that his confusion about the protection order was genuine and is genuine. Is no longer the case, though, that Mr. Ortega is confused about the protection order. So again, I think if the court is inclined to close him out with jail, obviously we would request that. He does have 9 days credit. Alternatively, we would be requesting a probation sentence so that Mr. Ortega can continue the good things he has going for him.
Mr. Ortega, is there anything else you'd like me to know?
No, Your Honor.
Mr. Ortega, a couple things I have to say. I know when you were served the restraining order back 20 years ago, they told you that permanent meant permanent. I did read the affidavits and I understand the mitigation that Mr. Fitzgerald is talking about. If this had been a recent restraining order, I wouldn't find it very much in mitigation because it is a court order. On the other hand, it's 20 plus years old. I don't often do this. And I know when I took you into custody, you were generally confused. And I told you that if you didn't post the bond, I'd consider reducing your bond, but you didn't even ask for bond here and you're just getting over. This is very rare for me. I'm going to order 15 days jail with 9 days credit and close the case out. I want there to be some consequence, but not slam you. But you need to understand that that restraining order, unless and until a judge vacates it, is still permanent.
Understand that now.
So that'll be the order and I'll close it out for you.
Thank you, Judge.
Thank you.
And may I also call Ms. Smith?
Did you think you had a case, sir?
Yeah, Victor Creel?
Let me check for you. Come on up here. I recognize the name. I don't recognize the person.
I think that's for tomorrow, Judge.
Yeah, I think so too.
Roger?
Let me check for you, okay? You said Victor?
Yes.
Mr. Carrillo, what's your first name, middle name?
Victor Dwayne?
You actually have a warrant
Oh, really?
and it's a domestic, and I can't. Let me look at it. You have 26M 526, which is on for arraignment, and you don't have a lawyer. The DA filed another case against you. And the allegations go back to March 30th.
Okay.
And here's what the allegations are, so you hear it. Oh, wait, March 30th, 1345.
A violation of a protection order, Your Honor,
Yeah, let me just check something.
because I can let the court know that
It looks to me like, no, one was December 29th, but it was arrested March 30th. $26M 526. Let me see something. Here's the allegation, sir. The allegation was that after being released from jail,
Mhm.
you went back to the house. And that's illegal because you were ordered not to, and that's why there's a warrant for your arrest.
Yes. Me and,
Wait, I'm gonna stop you because you have a right to remain silent and you've not been advised on that new charge.
Your Honor, if I may say something, part of the offer for tomorrow was the dismissal of that charge because at the time it was still pending charging for us. So they would.
But the restraining order had already been issued.
Okay, yeah. I just wanted to let the court be aware of that, if that would make a difference.
Counsel, what I'm willing to do, if that's what you want me to do, right now I set bond at 1,500 cash or surety. I can take them in and convert it to a PR bond. But it's not on the docket today. There's an active warrant that your office filed. And without DA consent, I'm not withdrawing the warrant. But your office filed that warrant on May 22nd. Or 27th. I can advise him today and put it on for tomorrow with the other case.
I think we should do that, Your Honor.
Mr. Carrillo, here's what I'm gonna do. I'm gonna change this to a PR bond, so you'll be out in about an hour or two, but I'm gonna have them book you. I'm gonna advise you and give you a mandatory protection order right now. Okay? You've heard me do the advisement before, but I'm gonna do it again. Actually, you were here when I did the plea. Did those rights make sense to you?
Yes, sir.
What you're charged with is just that. Going back to the house after you went through advisements and signed the restraining order, and that in the case for which you were already released, there was a mandatory protection order that Magistrate Christian ordered. I'm just pulling it up. That protected her and the address. So you need to understand that violating a protection order carries up to 364 days of jail. So I am ordering, as a protection order in this case, you cannot harass, molest, intimidate, retaliate, or tamper with any witness or victim, that you must stay 100 yards away from Katrina Zeller, Zeller, 45 of 81. The court is not finding that this is a domestic violence order. I'm also ordering that you stay 100 yards away from any address that she might be found.
Yes, sir.
I'll set bond at $1,500 personal recognizance. If you violate it again because you have 2 prior convictions for assault, I'll just keep you in custody till trial date. If it takes 6 months, it takes 6 months.
Yes, sir.
None means none. In fact, I will tell you the only reason I'm willing to even convert this to a PR is because the DA, Mr. Brim, I appreciate the candor on that very much, made an offer not to charge this one if there was a plea agreement in the other. That's the only reason. Otherwise, bond would have been set at about 10,000. Because my view is, if you can't even last 12 hours out of custody without violating it, you're telling me don't bother putting me on probation because I'm going to ignore court orders. But those conditions that I just went over are also bond conditions. Does that make sense?
Sir.
So here's what I'm going to do today. I'm going to have the deputies come in. They're going to arrest, they're going to book you, and they're going to release you on the PR bond that I just set.
Okay.
I'm going to make the PR bond returnable tomorrow morning at 8:30 with your other case. If you wish to apply for a public defender or hire a lawyer, you certainly have the right to do so. You already told me at least before you didn't qualify, but that's up to you. If you want to hire a lawyer, you can hire a lawyer. If you want to set the case for trial, I'll advise you about your trial rights again. If there's a plea agreement that you want to re-talk to Mr. Brennan about, we can do that. Okay? All right. Deputies, I just gave him a PR, but he has to be booked on it. No contact.
Sure, got him. I'm coming this way, okay?
And let me look at this. Let me look at the supervision level. Hold on. Mr. One more quick thing. I have to put a supervision level on. Yeah, I'm gonna move it to enhanced. You have to make sure you go to RMS because I am putting you on a slightly higher level of supervision.
Okay.
Enhanced. And obviously no contact with her.
Yes, sir.
All right.
Thank you.
See you tomorrow.
Right, Andrea Carter, 25 CR 3486.
Winslow for the people.
Morning, Honor. Stephanie Perkins appearing with Mr. Carter. He's in custody, Judge.
Good morning.
Good morning.
Yesterday, we set the sentencing over for today for Mr. Klein to be available. I believe he is present.
Yes, Your Honor, I believe he's on WebEx under the name Brad K.
All right, good morning. Do we have Brad Klein here?
I'm here, along with my,
Good morning.
good morning.
All right, we'll proceed to sentencing at this time. I'll start with Ms. Perkins, please.
Yes, Judge. In reviewing the victim impact statements, I just wanted to note that there were portions personally that applied to the previous co-defendant. Mr. Carter's never been out of custody. I'm not sure how this case ended up in this division. The other two co-defendants are in Division Q. Mr. Johnson did plead to the same charge and receive a 3-year Department of Corrections sentence, and Ms. Mercer is pending sentencing on an F4 plea as well. Mr. Carter has 179 days of pre-sentence confinement credit. I think what I want the court to know, his sister and his friend are here. They've been here for every court date. He does have good family and community support. He has always been gainfully employed when he is not in custody, usually doing manual labor jobs that unfortunately have been very hard on him and his body, including causing meningitis and causing him to lose a portion of his finger working at the packing plant. Mr. Carter obviously wants to apologize to the two named victims. I think, and not diminishing their loss in any way, this is an interesting kind of burglary. The apartment is not a ground floor apartment, and there was no signs of forced entry in that or the car. I have had suspicions that I've not been able to confirm that there was some potentially involvement from somebody that worked at the apartment complex or knew that the named victim was not going to be present and allowed Mr. Carter and the co-defendants inside. However, he realizes that he should not have been in there, utilizing those items and taking the items out. Some of the items were, including a bed, were in broad daylight being carried out, which is another reason I think that there was something else going on under that. Again, not to minimize his involvement or the impact it's had on the victim, but I do think this is an appropriate sentence for Mr. Carter. And I am asking the court to impose the 4 years of Department of Corrections with 179 days of pre-sentence confinement credit.
Thank you. For the people?
Thank you, Your Honor. And I would defer to Mr. Klein first if he'd like to make
Sure.
an additional statement. He has filed a really eloquent victim impact statement, but I'd like to give him the chance to speak to the court.
All right, good morning again, Mr. Klein. What would you like to say today?
Good morning, Your Honor. Just to confirm, we never wrote victim impact statements for this defendant. I know Theodore Johnson was sentenced to 3 years. Based off Andre Carter's criminal history, comparing it to Theodore Johnson's, I believe it's only fair that Andre Carter receives more than Theodore. I mean, Theodore at least took some accountability. To my understanding, Andre Carter has had 3 drug convictions in the time that he burglarized our apartment. And I don't want it to, I think the main focus is my wife's immigration documents, which I have clarified over and over again. There's clear evidence that they were intentionally stolen, that these defendants knew what they were stealing. All other USCIS documents were left at the apartment almost as a message saying, we're taking this, it has no monetary value to us, but we just want to fuck with your lives. And to me, it's really the act of not just taking these items of monetary value, which we have renter's insurance, it's no big deal. It's these effects will have lifelong consequences for my family, especially at a time in our country when immigrants are facing some unknown future, some volatility. To go and intentionally steal documents that you know have no personal value to you personally, but just to mess with someone simply for the love of the game. I mean, it comes down to sadism. It is quite evil. Andre Carter, to my understanding, has taken no accountability for this crime. I haven't heard him speak, and maybe he will. When the police searched the tent, he was hiding within that tent, trying to evade accountability. And when they did pull him out of the tent, he was wearing my clothes. I could go on and on. I guess the biggest focus here is this is not unique crime. He broke into our apartment on Christmas Eve or Christmas Day. I mean, how much more evil can you be to do that to someone on unarguably the biggest holiday in this country, and then to go and mess with people's lives? You know, steal my Xbox, steal the TV, steal the mattress, steal all this stuff. I don't really care. But it comes down to taking documents and pictures. And the other evil thing that I thought was very unique were the family pictures taken. And the way the family pictures were hung up inside his tent, they were almost put on his nightstand so he could look at them every night. It's weird. It is sadism. It's like a trophy for him. And to go back, you know, to Theodore Johnson's case, Theodore Johnson received 3 years. He took some sense of accountability. Andre Carter's criminal history looks like a college textbook to Theodore Johnson's comic book. I don't see in a world where Andre Carter should receive less time or the same amount of time as Theodore Johnson. You have anything, babe? I mean, I could go on forever, but I think I'll just leave it at that.
All right. Thank you so much. Thank you for being here and thank you for your statement.
Thank you, Your Honor. And I know Your Honor's had an opportunity to review the affidavit and facts in this case, but I'd like to just hit on a few things briefly that I think are really significant. There are 3 co-defendants in this case, and all of them, I think, share similar levels of culpability. Ultimately, the evidence, it can be hard to work through I think, to try and allocate specific blame for specific items to specific people. This apartment, they invaded the home and absolutely ransacked and destroyed it. Basically, everything that wasn't bolted down was taken out of this apartment or was damaged and destroyed in the home. There was forensic evidence in this case. Fingerprints of all the defendants were found within the home, on wine bottles, on different items. The family's Subaru was stolen from the apartment complex and used to transport some of their personal items back to the homeless encampment where these 3 individuals were living in tents. And the items stole were both of immense monetary and personal value to the Klein family. In speaking with the Kleins throughout the pendency of these 3 cases, they would like maximum prison sentences allowed by law on these charges. And frankly, that's understandable to me, given what they've lived through and the trauma of this event. I believe that Mr. Klein, you know, he's well-spoken, he's well-written, and has very accurately described, you know, the long-term impact on this case that it's had on their lives. But quickly, I would like to highlight a few other things. I think, and Mr. Klein did just mention the immigration documents of his wife. I think the impact of this crime goes beyond just an invasion of privacy and security. It impacts the way that they live their daily lives in this home or in this country. Their security in these communities. I don't need to belabor to the court how impactful and scary it is for Mrs. Klein to be living without immigration documents with the current state of affairs. The bulk of the personal items that were recovered from the encampment in this case were located in Mr. Carter's tent. When he was arrested, he was wearing Mr. Klein's clothing. I think that also speaks to the massive evasion of privacy here. I'm not sure if the photos were in Mr. Carter's tent. I know there were photos displayed in Mr. Johnson's tent. But the way that the personal items of this family were brought into these tents, into this encampment and put on display, worn, slept in, I think displays a level of voyeurism that is really concerning. As Ms. Perkins stated, Ms. Mercer is pending sentencing. We have not made a stipulated agreement in her case. She will be proceeding to open sentencing. And as did Mr. Johnson, he proceeded to open sentencing. In that case, I did argue for a 4-year sentence, and instead he received a 3-year DOC sentence. So I do think that a stipulated sentence to 4 years is appropriate here, given the similar levels of culpability between these defendants and in light of the criminal history. To resolve these cases, the people thought it was appropriate to make the same offer in all the cases because of some of the confusion with evidence and trying to, delineate who would be more or less culpable. All defendants have prior felonies. They all have prior aggravated history. And I do think that this is an appropriate resolution that accurately represents the harm that was caused to the Klein family, but also the harm that this behavior represents to the community at whole. This is something that is very concerning. This is a massive invasion of privacy. It's a massive risk to the community. And I think it's easy to say that these are just things, they can be replaced, but I think the invasion in someone's home, the impact that has, the long-term impact of that lack of security is incredibly impactful, and I think it would be impactful in any person in our community. A review of this defendant's criminal history is concerning. It outlines a life of assaultive behavior with drug and alcohol use, as well as a history of noncompliance with probation and community-based sanctions. Had we not reached a stipulation in this case, I would have been asking for a prison sentence regardless, due to how impactful and concerning this was. I believe that a 4-year Department of Corrections sentence is appropriate here. I think it accurately represents the severity of this crime, and I would ask the court to accept the stipulation at this time.
Thank you. Mr. Carter, good morning. You have the right to make a statement if you'd like to before you're sentenced.
And Judge, just before he says, I just wanted to clarify, Mr. Carter did not have a tent at this encampment. There was a tent that I think was attributed to Mr. Johnson, and then he was located in Ms. Mercer's tent. He was hiding. He did have an active warrant for a motor vehicle theft of a motorcycle that's been since resolved. Just wanted to clarify that. Did you want to say anything?
Yeah, I wanted to say, I am sorry to the family. I want to tell the family I am sorry. It's my first time ever made a statement or anything or say something, so I've been wanting to let them know that I was sorry for going and dwell in their house.
Thank you. Mr. Carter, in this case, has pled guilty to second-degree burglary and unauthorized use of a motor vehicle. The court has reviewed the court file in this case. I have reviewed the arrest affidavit, and I am familiar with the underlying nature of the facts of this case. I have considered the counsel's arguments today, the written statement and oral statements by Mr. Klein, one of the named victims in this case. I've considered Mr. Carter's statements today and the sentencing factors at 18-1-102.5. Certainly, anytime a home is burglarized, there's an incredible impact on that family. They feel violated and scared. And it's a terrifying experience to realize your things have been gone through and removed and then used by others. It's just a certain traumatic experience for this family to have endured. I appreciate that Mr. Carter has formally apologized today. To the extent that that has an impact on Mr. Klein, I think that's significant. I think it's important for people to hear that there is regret and taking accountability for those actions, which Mr. Carter has done in this case. Whenever the court is approached with a stipulated sentence, I'm always guided to simply do as I attempt to do in any case that I'm sentencing someone, which is to balance a number of different factors, which are certainly to encourage accountability and the acceptance of responsibility, to also recognize the nature of the offense and the gravity of it, to treat similarly situated offenders the same and fairly, to encourage that others don't commit similar crimes and encourage rehabilitation and reduce recidivism. It's just a number of different factors. This was a stipulated sentence that appear to be, and it continues to appear to be appropriate, given the similar levels of culpability between Mr. Carter and the co-defendants, and there's similarly situated conduct in this case and relative similar lack of criminal history. It's never going to be exact, but it is similar enough that it's within the bounds of reason for the court to accept. I think one of the benefits I would express to the Klein family is setting aside, and without diminishing, the loss of personal documents, which is an extraordinary, not only invasion of privacy, but a tremendous effort to replace. The stipulated sentence in this case, and one of the reasons the court did accept it, is because Mr. Carter, along with the co-defendant who has also pled already, are agreeing to repay all of the owed restitution in this case, which I understand to be over $16,000. So that is significant as well. It doesn't change what happened, but it at least is a step in some form of restoration for the victims. At this time, the court will impose the 4-year Department of Corrections sentence on the Class 4 felony. That will come with a mandatory 3-year period of parole. The court will note 179 days of pre-sentence confinement credit. On the Class 1 misdemeanor, the court will impose the 179 days and close that misdemeanor count with the time that's been served on that. The court will grant the request for joint and several restitution in this case as agreed to, and that's $16,864.99. There will be court costs applied. The court will dismiss the unprosecuted counts. Mr. Carter, do you have any questions regarding your sentence?
No, ma'am.
All right. Anything further from other counsel?
Your Honor, there was a misdemeanor we pulled up today.
Oh, that's right.
That's right.
They briefly a record on that. Ms. Perkins had me look at that, and interestingly, the charges in that case come from a warrant that was served, and in the reports, it indicates that Mr. Carter was contacted and arrested following the execution of this warrant. However, Mr. Carter has been in custody for the entire pendency of this matter. So it's a factual impossibility that that case belongs to him in particular. So at this time, I am moving to dismiss that case.
All right, thank you. Can you just place that case number on the record? I don't have it with me here.
Again, just one moment, Your Honor, I apologize.
My computer, I emailed.
Your Honor, it is, oh no. Your Honor, it is 26M951.
Thank you. The court will dismiss case number 26M951 on today's date. All right, thank you. Good luck to you, Mr. Carter, and thank you again, Mr. Klein, for being here.
Thank you, Your Honor.
Judge, we can go ahead and call the Medlin case. I think he might be stuck in the breakout. Oh, there we go.
All right, thank you. This is again 15 CR 1376, Trent Medlin.
Ricardo Bravo for the people.
Paige Hara for Mr. Medlin, who appears virtually and in custody from FWRC in Florida.
Thank you. Ms. Hare, how would you like to proceed today?
We are asking the court to accept an admission on the probation complaint in this case today, and our request is to proceed to immediate resentencing.
Okay, I can certainly proceed with the admission. I believe the named victim in this case did opt in.
And that is correct, Your Honor. And I've spoken to Ms. Kelly Hayes. She indicated to me that she did not plan on appearing, but she did send a victim impact statement that has been disclosed to the defense that she would like me to read on the record.
All right, well then we can proceed today. All right, Mr. Medlin, good morning again.
Good morning.
Your attorney has represented he'd like to enter into an admission to the probation complaint. First, do you understand that you do have the right to deny the allegations in the probation complaint and request a hearing?
Yes, ma'am.
And do you understand that by entering into the admission today, you do waive that right and we simply proceed to a resentencing on your case?
Yes, ma'am.
You were granted probation on a Class 4 felony, and that carries a presumptive sentence if incarcerated of 2 to 6 years in the Department of Corrections if incarcerated. Do you understand that sentencing range?
Yes, ma'am.
Today, are you under the influence of any alcohol, drug, or other medication that would affect your thinking?
No, ma'am.
Do you feel like you are thinking clearly today?
Yes, ma'am.
And have you had enough time to discuss this case and the effect of the admission with your counsel?
Yes, ma'am.
Is anyone forcing you, threatening you, or making you any promise in exchange for entering into the admission today? Is this what you want to do?
Yes, ma'am.
Understanding these rights then, how do you wish to plead? Do you wish to admit to violating probation, or do you wish to deny that and set it for a hearing?
I admit to violating probation.
Thank you. The court accepts the admission tendered by Mr. Medlin. I find he's tendered a knowing, voluntary, and intelligent admission to the probation complaint without undue influence or coercion. All right, regarding resentencing, Ms. Hare, I'll start with you.
I am asking the court to terminate probation in this case with Mr. Medlin's credit. Mr. Medlin, by my calculation, has 1,733 days of credit for time served. I understand that the presumptive range is the 2 to 6 years. My understanding is that Mr. Medlin is not aggravated or enhanced, so I do think that is the appropriate range for the court to be looking at. Ultimately, if Mr. Medlin were to get a 6-year sentence, well, I'll take a step back. So Mr. Medlin is currently serving a sentence in Florida that he has been incarcerated on since 2021. I know that some of this was sort of generally laid out in the filing from Mr. Medlin. Mr. Medlin is eligible next year to be moved to a work release program where he would be at a facility. It sounds like they have a dog training program there that Mr. Medlin is hoping to be able to take part in. And ultimately, he would be eligible for parole in 2029, where he would be released back into the community if paroled. With the amount of credit that he has, I believe that it wouldn't necessarily, assuming the court runs the sentence concurrent to the Florida case, it wouldn't necessarily prolong the sentence. Functionally, what it would do is require him to come back to Colorado to be paroled here. But the major impact would be that it would affect his ability to do that work release program next year. Mr. Medlin, when sentenced to probation on this case, he was married. He had connections to the military. He participated in a rehab facility, and then very quickly things became unstable for him. He was going through a divorce. He lost his housing, and things just sort of spiraled out of control. He is obviously coming before the court willing and able to admit that he messed up on probation, did not do what he was supposed to do. But ultimately, while incarcerated in Florida, he's been trying to better himself. He's been going to the chapel services in Florida. He's been engaging in certificate programs in construction and culinary programs. And he's based in Florida. So I think having to come back to Colorado, being on supervision in Florida and Colorado, having to get that moved over would only really serve to logistically make things more difficult for him. I think the cleanest way for the court to do this would be to just sentence Mr. Medlin to 90 days of jail as a condition of unsupervised probation, which would be satisfied by his credit. I would ask that the sentence be run concurrent to the Florida matter. I did get a case number for that. It's Duval County case 21-11-637. So that is our request today for the court to close this with credit.
Thank you. Mr. Bravo for the people.
Thank you, Your Honor. I will start off with Ms. Hayes's letter. She wrote, Your Honor, my name is Kelly Hayes, and I am the victim of case 15 CR 1376. This case has been pending since May 3rd, 2015 with the offender, and I apologize to Mr. Medlin, but in her letter, she did write Trishana Medlin, violating probation several times since then. I wrote my initial victim impact statement for the hearing on October 22nd, 2021. However, the offender fled the state and did not attend. Please take the time to read my last victim impact statement, as much of what I want to say for this hearing was already mentioned within my last one. The last few sentences of my previous victim impact statement read, all victims of the defendant, past, present, future, deserve to be protected. I request that the defendant serve the maximum prison sentence. I was fortunate enough to walk away from this abusive relationship alive, but the next victim may not be so lucky. Unfortunately, after writing this, another innocent woman fell victim to this abuser. The offender repeated her past violence on December 10th, 2021 by showing up to the other victim's apartment with a loaded firearm in Jacksonville, Florida, occurring 49 days after the offender failed to appear at this case's previous hearing. Fortunately, the victim's children were not at the residence, and the victim was removed from the situation by the police when they arrived. The offender then had a standoff with the Jacksonville SWAT team for hours. The offender proceeded to destroy her apartment, eventually slitting her wrist before being apprehended by the authorities. Within the past decade since this case, I have identified several criminal court records filed across the country listing Trishana Medlin as the offender. This does not include unfiled offenses or records other victims may have. Your Honor, the offender repeated violent behavior, repeated probation violations, and abuse of endless victims make it clear that rehabilitation is not possible. The offender will always be a danger to society and will always be looking for a new victim to abuse if released. How many chances does this violent offender get before I am protected and justice is served? For the sake of my safety, other victims' safety, and law enforcement safety, I am pleading for the offender, Trishana Medlin, to serve the maximum sentence possible. Thank you for hearing my voice, Kelly Hayes. Your Honor, the people are asking to revoke and terminate with a Department of Corrections sentence, and people have no objection running that concurrent to Mr. Medlin's current Florida prison sentence. The defendant absconded from probation back in 2020. The probation complaint noted that Mr. Medlin did not attend treatment and that he left to Florida without permission. Then in Florida, he was charged and convicted of that Florida case, and the conviction were for charges of assault and possession of a weapon. Defendant was then sentenced to a 10-year prison sentence. At this point, Your Honor, given that the defendant left the state, is serving a prison sentence in Florida, the people are asking for a concurrent prison sentence. Thank you.
Thank you. Mr. Medlin, you have the right to make a statement if you'd like to before you're resentenced in this case. Is there anything that you wanted to say?
Yes, ma'am. I would like to say that the person that I am today is not the person that I was in 2015 or 2021. I recently, the night that I got arrested in 2021, my brother, I thought, had passed away, and it triggered a very traumatic brain relapse for my mental health that night. And I pursued to kill myself. I went to I went to that address seeking help, not to destroy or destruct or cause any harm to anybody except for myself. My brother did not die that night. He ended up dying 8 months later while I was sitting in county on this case, waiting to be sentenced. And when he passed away, honestly, if I may speak frankly, it changed my life. If it wasn't for my brother passing away, I wouldn't be seeking the change within myself and to help and want to change a lot of the surrounding communities and do work with the LGBT community that I currently am involved with. Coming to Florida I should have never left the state. I understand that. I was wrong for that. I had nowhere to go. I lost my apartment. I suffered from a few things situational wise that it really prevented me and hindered my probation in Colorado while trying to finish that. So since being incarcerated, I've been on this compound for 5 years now, and I've done nothing but I got baptized. I've stayed involved with the community, with chapel here. I've done courses like my Miss Hare had mentioned, courses that have gained me certificates in construction management and culinary arts. I've also looked into a law school program out of Minneapolis that I'm still waiting to hear back from. I will say that since my brother's passing, I know a different life now, and I want to live it. If it's not for me, then it's for him and his memory and the legacy that he left behind. So I would like to be able to get home the quickest way possible to be able to bury him as well. Thank you. And again, I'm sorry to the courts for pretty much showing my rear for the last 10 years.
All right, thank you. All right, Mr. Medlin's before the court for resentencing, having previously been placed on probation for the Class 4 felony of second-degree assault. As an act of domestic violence, there was also an accompanying misdemeanor count of criminal mischief. The court has reviewed the entirety of the court file, including the original arrest affidavit, as well as the pre-sentence investigation report and reports from the probation department. As mentioned previously, this court previously sentenced Mr. Medlin and reinstated his probation on June 3rd of 2020. Notably, that was for, after a 4-year term of probation, the court reinstated Mr. Medlin's probation for a term of 1 year. However, within approximately 8 weeks, there were new law violations involving further acts of domestic violence, and that was from August of 2020. It was also outlined by the probation department that essentially after checking into probation, Mr. Medlin absconded, and as outlined in the report, this happened after he had previously been allowed to transfer supervision to the state of North Carolina and did not attend the domestic violence treatment as required. I appreciate today Mr. Medlin's statements that things are notably different than they were in 2021. I also am aware of the procedural history of this case and the impact that the original case had on the named victim, Ms. Hayes, who was also involved in the prior case, or this case, I should say, previously. I think when we have 2 different abscondments and then new law violations that are serious in nature, not only domestic violence, but also the felony offenses which have resulted in Mr. Medlin's current sentence, it would diminish the severity of these actions to simply say that he should receive an unsupervised probationary sentence and just close that out. I think that really diminishes and doesn't take into account the gravity of the conduct, which is leaving the state, not complying with any of the probationary requirements, and then committing new law violations that were serious in nature, all while Ms. Hayes is wondering what's going on and her safety still feels significantly placed at risk. So that's all to say, I'm not inclined to simply apply the credit and close the case. But I'll also recognize that at this point, Mr. Medlin has accrued a significant amount of credit, and I think it is fair to say that most of the sentence that will be imposed here will be likely served, with the exception that, as mentioned, it will require Mr. Medlin to be placed on a concurrent period of parole out of the state of Colorado. And that's just something that will have to be reckoned with down the road. And it may interrupt the programming Mr. Medlin had hoped to achieve pretty soon into the 10-year or halfway through the 10-year sentence that was previously imposed. I don't know the outcome of that. I recognize that that's a concern. I just don't find that to be a reason not to impose an appropriate sentence in this case. So the court will revoke and terminate probation on today's date. I'm imposing a 5-year Department of Corrections sentence. It will apply the 1,733 days of pre-sentence confinement credit to that 5-year sentence. There will be a 3-year mandatory parole period, and I will also allow this to run concurrent to the Florida Duval County case number 2111637. Mr. Medlin, do you have any questions regarding your sentence?
No, ma'am.
Okay, good luck to you. Thank you. Thank you again, Ms. Hare, for logging back on.
Of course.
We'll have the min-miss uploaded later today. Okay. Thank you.
Thank you. No, I think I'm done.
Yeah, okay. I know that they, let me get this thing off first. Oh, this is legal, isn't it?